The Supreme Court takes up their first major Second Amendment case in over a decade. We'll talk to CSGV's legal experts about exactly what this means right now on CSGV at Home. Hello and welcome to CSGV at Home. My name is Andrew Patrick and I'm the Director of Political Communications at the Coalition to Stop Gun Violence. This week, the Supreme Court granted cert, agreeing to hear the case New York State Pistol Association versus Corlett. To unpack all of this and what it means, we have CSGV's legal team, Kelly Roskam, the Senior Director of Law and Policy, and Tim Carey, our Law and Policy Staff Attorney. I want to thank you guys so much for taking the time.
Thanks, Andrew.
Yeah, thanks for having us.
So we've heard a lot about this. GVP activists are concerned about what's happening. I think gun rights groups are already popping champagne bottles. A lot of experts are saying this can go a myriad of different ways. No one really knows what's going to happen with this case. So there's varying outcomes. So Tim, can you break down in simple terms what exactly it is this case means?
Yeah, so New York State Rifle and Pistol Association, or otherwise known as NYSRPA versus Corlett, is a case that essentially grapples with this one question of whether New York's proper cause requirement to use concealed carry licenses for firearms in the public violates the plaintiff's Second Amendment rights. And so I'll tell more about the case to give that question some context. So this case kind of revolves around mainly two main plaintiffs, Robert Nash and Brandon Koch, who both applied for handgun concealed carry licenses for the state of New York, and their applications were granted. However, the state licensing officials of New York had the discretion to restrict the scope of the licenses, as well as whether to grant or deny them. So both of the plaintiffs in this case were granted restricted licenses to concealed carry for hunting and target shooting only, while the plaintiffs wanted to have licenses to allow them to carry around concealed handguns for the purpose of self-defense. However, New York's law, which has been in place since 1913 regarding this issue, so one of the oldest, states that an applicant for a concealed carry permit for a handgun must demonstrate a special need for protection distinguishable from that of the general community to satisfy what they consider a proper cause standard to carry a concealed handgun in public for the purposes of self-defense. So both the plaintiffs applied for these less restricted licenses and were denied for failing to demonstrate a proper cause to justify the additional privilege. For a little more context on what that means, New York is what's considered a may issue state for gun licensing, meaning that the licensing authorities have the discretion to limit or deny a license, even to do regarding firearms, even if the application meets the bare criteria to grant the license. Whereas the alternative to this model is a shall issue state, where if the applicant meets all the requirements in the application, then they are automatically granted the right to the license. Other examples of may issue states like New York include, with good cause requirements, include California, Delaware, Hawaii, Maryland, Massachusetts, and New Jersey, where Connecticut and DC have some more stringent standards where they may issue states without a good cause requirement. So they give their licensing board discretion to deny or grant or limit for any criteria. So this case was denied or dismissed by both the District Court in New York and the Second Circuit Court of Appeals, because the courts both noted that the New York licensing law was constitutional because it did not burden a recognized protected right under the Second Amendment of the Constitution, and that the proper cause requirement served the substantial government interest of public safety and crime prevention. So that's kind of a comprehensive look at the background of what this case is, why it is, and how it got to where we are today.
Okay, so Kelly, expanding on what Tim just said, what would you say is the importance of this case? And we obviously don't have a crystal ball, but what impact could it have?
Well, you're right, Andrew. We don't know what is going to happen in this case, but it's potentially the biggest Second Amendment case since Heller and McDonald. In 2008, in Heller versus the District of Columbia, the Supreme Court found for the very first time that the Second Amendment protected an individual right to possess a handgun in the home for the purpose of lawful self-defense, completely unconnected to malicious service. 2 years later, in McDonald versus Chicago, the court found that this new individual right was enforceable against the states. So the federal government cannot prohibit you as a law-abiding, responsible citizen from possessing a firearm in the home for the purpose of lawful self-defense. Neither can the states. Though the rulings in Heller and McDonald were careful to note that the Second Amendment right was not unlimited, it's not a right to carry any kind of firearm in any manner, anywhere that you want. But it left a number of open questions. This was limited to handgun possession inside the home. So one of those open questions is, to what extent, if at all, does the Second Amendment apply to carrying firearms outside the home in public? And how were lower courts supposed to evaluate these future Second Amendment claims? Heller and McDonald made clear that you can't prohibit possession of handguns in the home for self-defense, but what happens when the question is different, related to prohibitions on large capacity magazines or prohibitions on possession by persons who are convicted of felony offenses or misdemeanor crimes of domestic violence? All these questions were left, completely open by Heller and McDonald. So the court has an opportunity to clarify some of these questions.
Okay. So as the justices are looking at this case, what's the current framework that the lower courts have used that Tim talked about in there, when the lower courts are making their decision? What framework were they using?
Sure. So, it's been over a decade since the Supreme Court decided McDonald, and the
court looks a lot different.
The court looks a lot different. Yeah. Also, lower courts needed to come up with a way to evaluate these claims in this past decade. And so, the vast majority of these courts have settled on what they're calling either a two-step or a two-part test. So the court first asks, does the law or regulation burden conduct protected by the Second Amendment? Is the Second Amendment implicated at all in this case? So in answering that question, courts conduct an historical analysis. Long-standing laws, such as those that can be traced to the founding era, are generally understood to be outside the scope of the Second Amendment. And that's where the analysis ends. But if the law or regulation does burden conduct protected by the Second Amendment, that's not the end of the inquiry. It's not that at that point it's found to be unconstitutional. We move to the second part. And under that second part, the courts are determining a level of scrutiny to apply to that law or regulation. And in determining what that level is, they're asking two more questions. How close does the law come to the core of the Second Amendment right? And what is the severity of the law's burden on that right? So the farther from the core and the less severe the burden, courts are going to apply what's called intermediate scrutiny, which is sort of the middle level. And it requires that the law or regulation be substantially related to an important government interest. The closer to the core, or the more severe the burden, courts are going to apply strict scrutiny, a higher standard of review, which requires that a law or regulation be narrowly tailored to achieve a compelling government interest. So you should think of these as sort of a sliding scale. The more severe the burden, the closer to the core, the more exacting the analysis must be, a more important interest and a closer fit. So under this two-part framework, the vast majority of gun safety laws that have been challenged have been upheld. And those include prohibitions on persons convicted of felony offenses and misdemeanor crimes of domestic violence, as well as assault weapons, and large capacity magazine prohibitions. And this is, as Tim mentioned, the interest at stake in most, if not all of these cases, is public safety. Public safety has been found time and time again by the courts to be not just an important government interest, but a compelling government interest. And we've seen cases start to think even more broadly in the context of gun laws that protect not just public safety, but your right to participate in public life, to not be afraid to go to your legislature, to participate in democratic functions.
Do you have anything you want to add, Tim?
Well, I will say that there are a few potential implications stemming from this case. And again, a lot of it's speculative, but it's speculation grounded in the history of these justices' public opinions on these matters. Because as Kelly and you both stated, the Supreme Court's dynamics have shifted rather significantly since Heller was decided over 10 years ago. And though the lower courts have attempted to fill in ambiguities left in the Heller opinion on how to handle Second Amendment cases since then, several of the new justices have proposed alternative tests of their own. Now, I will say that as a preface going in, I feel, and again, speculation, that it's unlikely that the Supreme Court will use this case to recognize a fundamental constitutional right to carry firearms outside of the home, mainly because when the Supreme Court noted that they would take this case, they publicly stated that the only question this case will explicitly address is, quote, whether the state's, which New York's, denial of the petitioner's application for a concealed carry license for self-defense violated the Second Amendment. So that being said, it doesn't appear that the court will grapple with the constitutionality of public carry as a whole. And even if the Supreme Court did broaden its ruling to address public carry, it's unlikely that the court will extend the core of the Second Amendment protections from inside the home, as Heller declared, to the public places generally. And my thoughts on that stem from 2020 Supreme Court denial to take another gun rights case called Rogers v. Gerwal, where Justice Thomas dissented to the court's refusal to take the case. And again, I think this opinion came out in June 2020, so it was before Amy Coney Barrett joined the court. But in his dissent for the court's decision to not take the case, Justice Thomas was very clear in stating that, and I quote, "The right to carry arms for self-defense inherently includes the right to carry in public." So Justice Thomas is very clear that he believes that there is a constitutionally protected right to carry firearms in public spaces, which would completely upend the framework of essentially all of our gun laws. However, all the justices on the court at the time had the opportunity to join in on Thomas's dissent. And the only justice that joined part of Thomas's dissent in that opinion was Justice Kavanaugh, and he explicitly accepted himself from the part of the dissent that discussed this expansive view of public carry. So the fact that none of the other justices were openly sharing that expansive view of the Second Amendment right that Thomas had is a good sign that it seems that the whole of Second Amendment jurisprudence may not be upended on this case. But a much more likely consequence is that the framework that courts use to evaluate Second Amendment claims, like Kelly just stated, could be upended. And there are a few justices that have been open on the record on wanting to make that happen, namely Justice Thomas, Justice Kavanaugh, and Justice Barrett. Because also in the Rogers v. Gerwal dissent, Kavanaugh did join in on Justice Thomas's espousal of the support for what he calls a text history tradition test, where essentially the entire scope of what should be considered for Second Amendment claims and issues should be based solely on thorough historical analysis of and the tradition of how the Second Amendment right was drafted and the ideas and frames around gun laws and procedures at that time, and then applying that history to the modern day context. So this current balancing of interests we have, or we have history and court precedent that we then weigh against government interests and keeping the public safe. That interest balancing would be done away with, and it would be solely history based. And Justice Kavanaugh has been espousing that view since his dissent when he was a DC Circuit Judge in Heller 2 in 2011. So it's been something that he's been very consistent on for some time. Justice Barrett, on the other hand, her test is less applicable in this exact case, but there's still potential for it to arise here, and that's her dangerousness standard, where historically a lot of prohibitions on firearm possession, such as those who have been decided by courts to be mentally ill, or individuals who have been convicted of offenses punishable by more than 1 year's imprisonment, that typically are used to restrict firearm possession, Justice Barrett believes should only be applied to individuals who are determined by a court to be dangerous. And so those broad status prohibitions would be done away with, and every analysis would be individually tailored to that exact person to discern whether or not they're dangerous. And she espoused that view in her dissent in Cantor v. Barr, when she was also a judge before joining the Supreme Court. And she cited that opinion as one of her most important decisions or most important opinions from her time as a judge, which shows that it's something that's very core to her legal ideology. So it's very likely that we may see one of these two standards rear its head in the NYSRPA case, and that there's also potential for may issue firearms licenses to be dramatically changed, if not deemed unenforceable. But again, it's speculation. So
it's really interesting reading the tea leaves and kind of like seeing what we might end up with. Yeah, we all know Thomas wants guns everywhere and us to just shoot it out, and who's ever left standing. So so when can we expect a decision?
So this case will be taken up in the next Supreme Court term, which begins in October. We're likely to see the oral argument scheduled either in the fall or the spring, which is hopefully going to give us a little better sense of where the justices fall in this case. For more controversial opinions at the court, it's typical that you won't see an opinion until June of that term, so perhaps not for another year. So in the meantime, we'll be monitoring the case and thinking about court strategy. I want to note that this is not all doom and gloom. It's possible that the court would uphold this New York law. It's really hard to say based on the new makeup of the court and everything that's been happening in our society today.
All right, guys. Well, thank you so much. Thank you for sharing your insight. This is very interesting. We're going to be watching it for, like you said, probably a year. Thank you for making the time. So we'll talk to you guys soon.
Thanks, Andrew.
thank you.